Ms. Krisman, you filed on March 12th of 25, a motion to modify parenting time and an affidavit pursuant to 23-37209. Scheduled the matter for hearing. Again, that was also filed on March 12th at 12:19. Notice was given to Mr. Steely, and he was provided with the meeting ID and passcode in the notice. And of course, I think he's aware that he can always come to the courthouse. I think he's even done that before. And then notice was mailed to his address on Fraser Street that he's had for quite some time. So I think sufficient notice of this motion has been given. And an affidavit's been filed. Frankly, this case has quite the background, and I'm not even going to go into all of it, but sometimes Mr. Steely participates and sometimes he gets angry and he doesn't, and sometimes he's in trouble and reluctant to appear. So I have no idea why he hasn't appeared. But I do believe he's been given proper notice. There was some extensive conciliation that was done in this case. There was a very extensive almost reintegration after an emergency order had been filed and his parenting time was significantly restricted. And I'm frankly not that sure how far he got, because it was a very, very specific graduated program. He had to do so many things for 6 months, and then he could increase his time. And then he had classes, and with him not here to prove to me what he's done, I'm not sure what stage he is with this parenting plan that was not only a current plan, but it was a projected future plan to keep the parties from having to go back every time there was progress, or frankly, every time there was a deterioration with regard to him exercising his parenting time. Now, I understand that the crux of this motion, Ms. Krisman, is that your client has gotten remarried and is wanting to move closer to her spouse's family into, I think it's Illinois. And that frankly would significantly alter the ability for parenting time by being several states away. But I'll let you go ahead and argue your motion. I do want to see where statutory notification was given to him about her decision to move. I will also note, again, this conciliation is very detailed and very contingent and conditional upon progress with it. So I'm not sure where the mediator intended to shift some of these parenting agreements, that what accomplishments he had to make before he was entitled to object. But I will note page 13 requires that if a party moves out of state, they have to have a planning conversation with the other co-parent at least 6 months prior to any changes going into effect, and reach a mutually agreeable solution, create a transition plan and new parenting schedule that adequately reflects the new living circumstances. Then I will refer you to page 25. And I'm not sure there's much application there. That's more to do with introduction of a new parent or significant other with regard to serious relationships. Obviously, she's remarried, so but I do want to make sure that we've noted provisions that I've adopted in this current parenting plan based on recommendations that were adopted, to make sure that you have to give the statutory notice, but make sure that we're not in conflict with the parenting plan, or there's some basis for the court to disregard those additional provisions that aren't statutory in nature. Okay, I'm ready for you.
Thank you, Judge. And that was an excellent presentation of the status of the case and kind of the background. So I will skip most of that, other than highlighting that the parties were divorced in 2016. They started with shared residential. The courts modified this several times, each time based on father's behaviors has slowly decreased his time. At this point, the court was asking where father was at in the phased parenting plan. Father was in phase 1 of the parenting plan that was reached in the domestic conciliation, giving him 1.79% of the total parenting time. He was ordered to complete several tasks to reintegrate and increase that time. He did not complete those tasks at all, any tasks at all, and he never advanced past that step. The court is obviously aware that father, that was entered in March of 2024. Father then got arrested on many felonies, and he actually just had his preliminary hearing and was bound over for trial on the 25th of this month. Father did not complete any of the steps that were ordered in that March 7, 2024 hearing, in which the strict orders for co-parenting successfully were clarified by the court. He was ordered to complete the batter's intervention assessment. He was to complete the flagged program modules no later than August 31st of 2024. He was ordered to participate in family counseling with his daughter's therapist. He has never been willing to engage in any of that counseling. He was ordered to participate in individual counseling. He never did that. And so he never advanced past that first stage. Father, the only thing that father has done since we were last in court was that he sent mother an unverified picture of a negative urinalysis, which would have gone back about 72 hours. There was no lab report. There was nothing certified, nothing signed. We don't know the veracity of that. But frankly, my client's biggest concern is his mental health and the impact that some of his conversations have on the child. Father's had contact with the child twice since October of 2024, when his parenting time was suspended. On Christmas, and this is also in my motion, on Christmas, he had a phone call with Amaya, who's 11, so she's old enough to kind of process some of these things, and she's in counseling herself. But he instructed her to stop contacting him. During that same call, he said that he and Amaya had nothing left to talk about. When my client had contacted him regarding scheduling virtual visits with her by phone or by video, he instructed mother to stop contacting him and that he did not want those virtual visits. He will not speak to the child. He doesn't have any meaningful contact, and he did threaten mom with filing a restraining order if she continued to contact him about the child. The next time he had any contact with the child was after he received an emailed copy of these pleadings from my office. He did reach out to my client, and he asked her to talk to the child. He then started crying profusely, bashing my client, saying he wished he'd never met her, wished he'd never had this child, that he's done everything he's supposed to do to be able to see her, that mom is just trying to replace him. The child was visibly uncomfortable. She was trying to redirect the conversation, talk about volleyball, talk about activities, talk about how she would be excited if she moved, that sort of thing. And father redirected the conversation back and essentially said, well, I'll never get to participate in any of that because your mother hates me, doesn't want to be involved with me. We did submit exhibits to your office in which my client, so exhibit 1 is some text messages. My client is reaching out, trying to talk to him about him saying he doesn't want to have contact with Amaya. He calls my client a robot. And excuse my language here, he tells my client to proceed with kissing his ass and that he hopes that cancer finds her, or even better. He says that she's fake, everything, including her soul. And then he proceeds to say that he can't afford any of the classes the courts ordered him to do in this case to reintegrate, despite the fact that over $33,000 was seized during his arrest in October. So he obviously was liquid at some point in time. And from March to October, he didn't use any of those $33,000 to do any steps, take any classes, do anything to reintegrate with the child. My client has not sent the restricted letter by certified mail return receipt requested. She will not be moving if she can't take her child. And so she's not anticipating moving in the next 30 days. She would like to move before the child is able to start school in August. She does feel that the move would be in the best interest of the child. Father is facing a significant amount of prison time. It's not likely that he's going to be able to exercise any parenting time or that he's inclined to do anything that makes him entitled to do so. It's not going to prejudice father whatsoever for mom to be allowed to move. The child would remain in school through the end of this school year, and she would want to potentially move in the summer so that the child could start in August of next year. I believe that satisfies the 6-month requirement as this was sent out to him after it was filed on March 12th.
There was one other provision in there about the parties agreeing that they would not change schools, that they were happy with her school, but I noted in your motion that there has been some, well, mom just feels like a smaller class size might better, and a little more one-on-one attention might be better for her. I'm trying to remember that, I should know this, but the recommendations on from the conciliation were adopted and came before his major arrest. It's just that it took a long time for the order to be actually filed, if I recall. So this was from a hearing from March 7th of 2024. And that's what adopted the Exhibit A, the parenting plan and the parenting plan recommendations. And then I don't think it's a full printout, but I have a printout of his criminal case 2024 CR 460. And he was charged in that case in October of 24. So I think what I'm going to have you do is I'm going to order that she return to Miss, I can't remember if it's Miss Krisman with Collaborative,
for the DC was Marcus Meyer. The only concern that we have there, if the court recalls, well, first off, Mr. Steely has not paid for the previous services.
Right,
So we're not certain that Marcus will take them back, but if the court will recall, Mr. Meyer did submit several communications where Mr. Steely was particularly nasty to him.
yes,
So if he's willing to take them back, certainly my
well,
client.
that's true. Well, in the order, I want you to put for limited purposes. I just want him to review generally what's transpired from the adoption of the phased program, including his arrest for possession with intent to distribute marijuana and cash being seized and all of that, to see, for him to confirm that there has not been substantial progress in the phased parenting time. And then let her explain the move and the school change and make sure that he confirms that that's in the best interest of the child. And I believe he'll be independent, but I believe he'll consider all the circumstances and make further recommendations. I'm not asking them to go back to mediation at all. I'm just asking her to go back and update them with what has and hasn't happened, because this was a projected plan, like I said, and so they need to know where he was at, and then what additionally has happened, and then whether that modifies their recommendation and their opinion on moving the child. So, because I think what we'll be doing essentially is shifting from joint custody to sole custody. Because, I mean, based on his rejection of the child, based on his long history of inconsistency and frankly disruptive behavior, they cannot communicate to the extent that they could co-parent long distance in a joint custody situation. So I am asking if since she's not planning to move until summer, I am asking that she go back and I get some basic information. I didn't think it was Marcus. I thought, hang on a minute. I've looked at a lot of reports today, so my apologies.
Judge, looking at page 32 of the recommendation, it is signed by Marcus Meyer.
Okay. Okay. So that's who she should go back to. And yeah, I do remember he's the one that did the emails trying to collect, but it must have been the last report I looked at that was done by someone else in that office, same office. But so that's, and if he says I'm not willing or interested in doing that, I think he'll let me know. And then I just may have to have her under oath and just do an evidentiary hearing and make some decisions. But right now he's not responded by default. I can potentially adopt your requests today. The problem is that he can appeal, and he may appeal if I don't make particular findings. And I'm more comfortable making particular findings by going back to the facility that spent the most time with them and detailed out clearly what they thought was in the child's best interest, and get updated information, not only on him, but on mom's present circumstances and what she intends or plans or desires to do. Okay.
Certainly.
Hopefully that won't take real long.
Do we want to set a review or do you want? to just-
Yes. Can we just see where you're at with this and touch base on May 15th at 3? And if you just, if basically you just email us and say she's had an appointment, or she has an appointment, or she's met with him a couple times, and you're just waiting for a letter. Be sure he knows when this court date is if I've got something by then I can just make rulings at that point.
Sure.
But he
to-
may not, there isn't always a rapid, they're very detailed, but there isn't always a rapid turnaround. And you can tell me that too, and then we can reset it.
To avoid the 2-week waiting period, submitting Rule 170, am I authorized to just file the order since he did not appear?
Yeah, I make the findings by default. Okay, sounds good. Let me look here. See. Yeah, you sent me a news article. I looked at his case. For the record too, he hired Charlie O'Hara's office out of Wichita for his criminal case. He hired private counsel. He has repeatedly advised this court that he had no money to hire an attorney in this case. And so Ms. Jones has paid extensive attorney's fees for her attorney to conduct a hearing with him self-representing and doing all of the journal entries and all of the pleadings. So I just want to mention, he has an attorney in the criminal case. They do civil work at that firm. They have very capable attorneys there. And no one from that office is entered in this case. No domestic attorney is entered in this case in response either to your motion. So. The other thing I was going to say is he waived preliminary hearing and was bound over for arraignment, and his arraignment is in front of Judge Crum on May 19th at 2:30. So this will be before his arraignment, but that's fine. The 15th hearing at 3.
And Judge, I don't know if it matters for the record. The court did order that his visitation would be suspended until the disposition of his pending criminal case. So we will still be well within that as well.
Yes. Okay. All right, very good. I think that's another finding the court can make, is essentially he's not only has he not made the progress for the court to advance him in his phased plan, but due to the seriousness of this criminal case, his time has been suspended. So, and I think a final update and clarification, there might be some clarification of that plan, because he never got past phase 1. So, okay, anything further today?
I don't believe so, Judge.
All right. Thank you very much. We are adjourned.
Thank you.